Hey everyone, welcome back to the Money Class podcast. Now this episode is a little bit different. We decided to get out of our comfort zones and explore a topic we knew nothing about. And it is a very complex and broad topic, but we think it is very relevant to everything we do today, especially with the internet. So with that being said, we introduce to you Daniel Drapeau and Nicolas Bertram, both intellectual property law lawyers, talking about, intellectual property law. Here's the episode. We hope you enjoy it. Hey everyone, welcome back to the Money Class podcast. My name is Kosta.
And here it's Marc.
And today is a very special episode on intellectual property. We have two special guests. And to begin, please introduce yourself. Who are you? What do you do?
So Nick, if you want to go ahead and take it from here.
Hi everyone. My name is Nicholas Bertram. I'm an intellectual property lawyer, patent agent, and trademark agent. And a big portion or significant portion of my practice involves preparing patent applications, and by preparing those patent applications is to protect people's inventions.
How long have you been practicing, Nicholas?
Just a little bit under 10 years now. So it's been a while. It goes by quite quickly.
Yeah, no, definitely. And how about you? Daniel?
My name is Daniel Drapeau. I am an intellectual property lawyer and a litigator and a trademark agent. And I litigate. I also advise clients on how to avoid litigation, how to get themselves out of litigation. And I also have a part of my practice, which is trademark prosecution. So it's registering trademarks. I have been at it for 30 years now in October. And this is Dagmar. And we'll pipe up every now and then whenever she feels that we're talking.
Well, she's definitely welcome on the podcast and can spend as much time as she wants. We'll give her a place as well. And I guess before we start diving into the questions, let's just define really what is intellectual property to each of you, right? There's obviously a dictionary definition, but what is it? What is its use in society, and why is it important for you to protect intellectual property? Pretty much your inventions, your ideas, and so forth.
Maybe I can start.
Yeah.
The way, Marc, that you phrased it is good. You said, what exactly does it entail? So the purpose of intellectual property, and anyway, my view, again, Daniel may have a different view, is to protect the fruits of intellectual labor. The efforts of the intellectual efforts that are made by certain parties in order to ensure or to provide those parties with a way of retaining a certain level of ownership on those rights.
Mm-hmm. Okay, great. And so with that being said, we do know that intellectual property has a lot of different branches. Can we get a bigger idea of what they are and what they all basically mean? Can we define it and go from there?
Yeah, there's 4 pillars to intellectual property, and each of them protects a different aspect of the fruits of one's mind. So first, you have patents. And every time I explain a right, I will have a word that encapsulates that right. So the word for patents is invention and functionality. So when someone comes up with something that is new, a new way of doing something, a new product, that is protected by patent. You will notice throughout what I will be explaining to you that I will never once mention the word idea. There is no protection in ideas. What is protected is the embodiment of the idea. So patent is an invention that is for something that is functional. So it's usually going to be a product or a method of doing a product. The other pillar is trademarks. It's a bit of a misnomer to lump in trademarks in intellectual property, because trademarks, while somebody can come up with the trademark, it's really more an aspect of commercial law. So a trademark is a sign, and I'm using the word very broadly, that distinguishes the source of one product or service from the source of another product or service. So the word for trademarks is distinguishing. Now that sign can be a wide variety of things. We're all familiar with logos. So the golden arches for McDonald's. The word McDonald's is a trademark, but trademarks are much broader than that. You can have flavors, you can have textures, you can have sounds, you can have holograms. There's even a way to protect the shape of a product by way of trademark. We'll get into that a little bit later on. Third pillar is copyright. The word for copyright is a work. So it's either a literary, a dramatic, a musical, or an artistic work. And copyright, in my view, really is the fruit of the mind. Somebody had an idea and they embodied that idea in a literal expression. The best example for that is if I tell you boy meets girl, boy and girl come from warring families, girl learns that boy got killed, girl commits suicide, boy who didn't get killed, he realizes that girl committed suicide, so then he commits suicide. What have I just described?
That's a book. It could be a novel.
A story,
Yes.
yeah.
A story.
What story have I just described? All right. So it's Romeo and Juliet, but it could be the ballet from Prokofiev. It could be the book by William Shakespeare. It could be a movie that was filmed about 15 years ago, actually, not too far from this house. It could be a variety of things. Each of those works has a copyright that's attached to it. Of course, the book by William Shakespeare, the copyright is now expired. But the movie that was filmed 15 years ago, quite close to my house, that still has copyright attachment to it. So the word for copyright is work, and it can be either literary, dramatic, musical, or artistic. And finally, the fourth pillar is industrial design. So in industrial design, and in the States, they call it design patent. In France, they call it modèle. So there's different names depending on the jurisdiction that you're in. But essentially here, what you're aiming to protect is a visual characteristic on a product. It is not a functional characteristic. It is only a characteristic that appeals to the eye. And we'll talk about that later on when we talk about the interplay of trademarks, industrial design, and copyright to protect the shape of a product. Then there could be a fifth element, which is trade secrets, which is really, when you think about it, the antithesis of the work that we do. Nick and I are in the field of protecting. You can also protect a right by never revealing what a composition would be. An example would be the recipe for the drink called Chartreuse, which is the recipe is under the custodianship of monks, and there's not one monk that has the entire recipe. That recipe has survived in secret for hundreds of years. That's an example of a trade secret. Problem is, a trade secret is it's only as good as the secret is.
Mm-hmm.
Once the secret is out, you don't have any protection.
So you're not as protected versus the other ones, which are set in stone, that there's a paper application.
Not as protected, or you're even more protected. Duration, all these rights that I've mentioned, they have a limited time frame, except for trademarks, which can be potentially eternal, but under certain conditions. Whereas a trade secret, if it stays secret, you can have eternal protection, but the day the secret's out, you have no more protection.
So you're playing with risk, essentially. A good example of a secret that hasn't been out, and it's been, I think, over 100 years, is Coca-Cola. The recipe for Coca-Cola, compared to, say, if they had basically tried to, quote unquote, formalize it with contracts and everything, it would have been out in the public domain. Is that right? Or it would have been out in the public?
Right. So if the Coca-Cola company decided that they were going to embody or put the recipe in a patent application, that patent application is a document that gets published. And the recipe and anything that is indicated in that application is also becomes accessible to the public. It can be accessed by the public. So it's true that in that case, the fact that they managed to retain secrecy over the recipe has prevented the public from gaining access to it. So there was a decision that provided them with a level of secrecy on the recipe that is far longer than ultimately if they would have shared the recipe in a patent application.
I see.
Yeah. It's interesting how, you would have a company like Coca-Cola, which obviously has a product that's there, we're able to actually see the correlation with what they want to hide with it, which is what they want to hide their recipe with, their final product, the actual, the Coke, the beverage. Though, do people sometimes protect things just for the sake of protecting them? Let's say I come up with an idea as I'm sleeping and I have a dream of this incredible product that could become a reality. What are there cases, or have you seen cases where people just want to protect that idea for its artistic value, or is patenting really just used for commercial uses?
Well, that's it. You're mixing concepts. Protecting something for its artistic value, that's copyright. Copyright protection exists. It's the only right where you don't have to do really anything other than just coming up, not with the idea, coming up with the literal expression of the idea. So just the idea of a disastrous love story, that doesn't suffice. You have to reduce your idea to a book, a movie, a ballet. So that's one thing. But copyright, your protection exists by virtue of the mere act of creation. You can get a registration, but it's not obligatory to have a registration in order to enforce your copyright. Once you start getting into the other rights, you're really looking at something that you need to make some money out of it. Otherwise, why are you spending to protect your right? So patents would probably be the most expensive right to obtain, the one that probably takes the longest to obtain. After that, trademarks, you can have rights in a trademark without having a registration, but you have to have use of the mark, which means that you have to have commercialization. So you're already going to have a business step in order to acquire rights. And industrial designs, you will also use that in a commercial context. So it's not like you're going to wake up one morning. I mean, I'm not saying that nobody's ever done it, but generally speaking, you're not going to wake up one morning and go to the patent office or go to the industrial design office or start commercializing a product and without thinking about what it is you're going to protect, how much it's going to cost, how you're going to recoup your investment, what's the ambit of protection that you're going to get. The main idea being to prevent others from coming close to what you're doing. That is the art that Nick and I specialize in. It's etching out a competitive space for your clients so that they are free to operate without interference from others, or if others interfere, that they have some grounds to stop them from interfering.
Right. And Daniel, it's well said. I mean, the thing is that if someone comes and sees you with an idea for a patent application for a patent, and they haven't actually thought up of how that idea will manifest itself in a product and how that product will ultimately be commercialized, the investment, the amount of money that needs to be invested in a patent application may not necessarily bear fruit. Mm-hmm. It's far safer to come up with an idea, understand how that idea is going to ultimately translate into profit for an eventual business, and then approach a patent agent or an intellectual property professional.
Okay.
Yeah, because that specific, that step of understanding where the business is going to go is going to allow you to ultimately translate the cost of the patent application in something that is going to provide an asset for the company when that company gets sold. The danger is to have a patent application and just sit on it. So you're spending the costs that are required, which if you're just filing in Canada, you could be spending anywhere between maybe $10,000 to $15,000 for something that you're just going to sit on and that is not ultimately going to give you any value because you don't really understand where the company is going to be going just based on that idea.
Okay, so you just mentioned the cost that you would have to incur in order to make the patent, because you need a viable business in order that you want to protect. But then there are other companies that have their patents that are pretty much open, or at least that people are allowed to use the processes that have been developed in the patent for their own commercial use. And I think an example would be Tesla in their electric car in the electric car market, and how they have their patents pretty much open to the public, or at least people are allowed to use the technology, or at least use the innovations that Tesla has developed. Nick, we had spoken about this last week when we were on the phone, and I was just wondering if you could kind of explain to us what this really means, for Tesla, but also for other companies that want to use their technology.
Right. So when you own a patent, so first of all, let's backtrack to what is a patent, right? Is that once you have a patent, the government is providing you with the right to exclude others from doing the invention as is being defined in that patent. So what that means is that third parties are not able to reproduce the invention as is described in this legal document that is this patent. Some companies, have decided to enforce or to license their patent in certain ways. As you are an owner of a right, just like if you own a car or you own a house, you have the choice to provide others. You can give access to that house, to that car, to other people. It's the same with a patent. It's an asset. And similarly, you can license that patent in a different way. And some companies like Tesla have chosen to provide access to, in other words, to give use to the inventions described in the patent, while they say that they're not going to necessarily enforce the patent on those parties, those parties that would be infringing if not for that authorization to use. But the thing is that when you're in a situation where you're benefiting from someone else's rights, or in other words, you're operating within the confines of a licensing agreement, because usually these are licensings. You're giving someone an authorization to use through a license. You have to read the fine print of that license, and some companies stipulate, for instance, that they provide you with free use to use the inventions as described in the patent, but on the other hand, you may not be able to enforce your own rights that are derived from that technology against that company. So the thing is that it's a little bit like in some cases, open source licenses may also limit what you can do with the product of your work that is basing itself on that technology that is either an open source technology, or in this case, the patent technology that is given free access to others. So look at the license; it's very important, because it could also stunt your own the full scope of what you can do with whatever you're inventing from that initial technology.
Interesting. So on the, sorry, yeah, go ahead.
No, I was gonna say, Dan, do you have anything to add to what Nick said?
Not really. I mean, I'm not a big believer in open source stuff. I mean, there may be a business imperative. Sorry, not a business imperative. There may be a business strategy, like if they make it open source, part of the conditions you have to agree to access is that if you make any improvements on the invention, then Tesla can use them. Mm-hmm. I see that happening. Is just that it then becomes very difficult to quantify what's the value of anything. So I think I prefer to go the traditional way. You have your rights and you make money off of those rights.
Yeah. Okay. So because if now you use Tesla's patent as a base and then you make new innovations, these innovations are now Tesla. So now what's your incentive to innovate further when the rights are going to someone else?
Well, the new innovations that you're creating are not Tesla's innovations, but because you're benefiting from a license that Tesla is putting out there, you have to look at that license to see what can you do with the technology that is derived from Tesla's technology. So I'm just main, because it's an important nuance, is that you are still the owner of what you create. If you're creating an improvement over someone else's technology. Yet it's just that but the thing is, what's it gets a little more complex is that when you're using technology that is being, technology that is being offered to you under license, that license is a contract, right? It's a contract between you and between that company. So in this case, say Tesla. And that particular contract is binding upon you. And it may actually limit what you can do with the technology, which means that if you decide if you're in breach of that contract, then, in this case, again, hypothetically, Tesla could go after you for breach of contract. They have a contract, remedy against you. They don't have a property right against you, but they have a contract.
Necessarily, depending on what the contract says, remember that even if you make an improvement over somebody else's invention, you can still infringe the underlying patent upon which you've improved because you're practicing patent.
Yeah.
Which means that in the contract, if, let's say, Tesla were to say, you have open access to my invention, but it doesn't say you can practice your own improvements, that means they could potentially go after them for practicing their own improvements.
Well, and it's an interesting point. So in other words, there's always a risk that you're infringing the underlying patent, Tesla's patent, on which you're basing your improvement on. And then it really does, it's a question of looking at the fine print of that license, which is why, and I think it goes back to what I think Daniel and I are saying is, when you're getting something for free, be very, very careful, what ultimately you're getting out of it. And as Daniel mentioned, I agree, is that when a client uses open source technology, or if ever they were to benefit, say, from, a pool of patents, such as the one that's being offered here that we're discussing, I would say, be very careful when doing that, because you're not really sure what you're getting into and how that could limit your own business's prospects in the future. So you have to be careful. And they may have other patents that are not under license as well that they could enforce against you. So that's another thing too.
Yeah, because if something is for free, in that case, then there's always nothing is ever for free, right? And whether it be social media, which is used for free, but then you end up being the product, not the service that you think that is the product in the business model.
Say I have, say I'm a company and I own 300 patents. I say, you guys are, anyone has free access to 50 of those patents. There's another company that uses those 50 patents to develop their own technology. However, there's those other 250 patents that are still out there that they could still infringe, and they could complement very nicely with those 50 patents that I've offered to license. So there are other variables that can also play, in that can also be that can come up, and that can also affect you in a negative way down the road.
Now,
yeah, that's interesting.
Yeah, so now I kind of want to move towards a different topic and idea, considering we have a very young audience, and our generation grew up on things like YouTube, I guess, the internet, Netflix, all of that stuff. There seems to be a big, or at least we see it a lot on the news, and there seems to be a big confusion with things like fair use and parody. So the question I want to ask you is, how does fair use and parody differ, especially on platforms, say like a YouTube, where people can just publish whatever they create and distribute it to the world?
Daniel, do you want to take it away?
I'm going to leave Daniel.
Listen, these are, I have to announce right from the outset, I'm an enforcer. I'm not an avoider. And what I found with most of these exceptions is that people always try to invoke them to kind of justify ex post facto what they've been doing. So I'm not a big fan to start out with. Mm-hmm. So I'm perhaps not the best person to present these exceptions. But as a litigator, what I can tell you is that they are exceptions to the general rule that you have protection over the literal expression of your idea, or whatever it may be. And as any exception, you have to fit within the four corners of the exception, and often exceptions are read narrowly. So I would be very careful, and I realize that there's a certain segment of academia that is very much in favor of fair use and very much in favor of the exceptions to copyright. They're often called copyleft. I don't fall within that category. So that's why I'm prefacing by saying I might not be the best guy to explain these to you, or rather I have my own bend on them. So generally fair use, one example will be for educational purposes, but you really have to go through the Copyright Act, and we will not have the time to do all of this tonight. You really have to go through the Copyright Act to figure out what are the qualifications that you have to meet in order to fall under, for example, the education exception. Parody is a different kettle of fish. Parody is when you mimic something, but the primary aim has to be to make fun of something else. But remember, the overarching principle is that there is copyright protection. Once you get caught with your pants down, then you start arguing, oh, but I was doing a parody. Yeah, well, guess what? Was it really a parody? Was it really to make fun of something else, or was it to make money off something else? So then you get into that sort of debate. So my short answer to this is be careful with those exceptions. Make sure that you fall within the four corners, and we could have a whole other podcast on where the qualifications meet under each. But be very wary that there's going to be somebody on the other side who's going to argue that you don't fall within the four corners of the exception.
So you really have to be certain that your intention has to be clear from the get-go. It can't be, unclear, because then you may be infringing on copyright. You really have to be sure that it really looks like a parody. It's satirical, or not satirical, but at least the humor is obvious. So that you're not stuck in between the lines and then up to the interpretation of a judge, let's say, to make a decision.
Yeah, and then, make sure you've got clean hands. Are you making money off of it? Are you prejudicing the other person's ability to make money? I mean, those are all ambient factors that one should look at, because that is how you will be painted if ever there's a dispute.
Mm-hmm. Okay, that makes sense.
I have one more question regarding this topic. A thing we see a lot in Montreal is, people put masks on sculptures, especially now with the pandemic. That seems to be a trend. Is that infringing on copyright or parody? Is it, because again, you keep on mentioning the commercial purposes. There's no real commercial.
Well, no, here that's quite different. Actually, there's a Canadian press bang on. It's the Michael Snow case. So here, what you are infringing on is moral rights. So moral right is an adjunct of copyright. I didn't cover it in the pillars because it's kind of part and parcel of copyright. Moral right is the author's right to either be identified as the author of the work or remain anonymous. And then there's three rights. So one is identification of author or anonymity. Second right is the right to the integrity of the work, so the right not to see your work modified. And thirdly, the right not to see your work associated with a cause or a business or something that would be prejudicial to you. So you have to establish this prejudicial. So the example here is Michael Snow. On the roof of the Eaton Centre in Toronto, there are sculptures of geese. So it's a flock of geese that's flying underneath the roof of the Eaton. They're suspended from the roof. And one Christmas, somebody at the Eaton Centre thought it would be a brilliant idea to put red scarves around the geese. And Michael Snow lost it. His analogy was basically, by doing this, you're basically doing the same thing as putting earrings on the Venus de Milo. And he won his case on moral rights infringement, and the Eaton Centre had to take down the scarves from the geese. So here, I think it really depends. I think, if you're looking, I'm thinking there may still be a sculpture of Les Bourgeois de Calais on Sherbrooke Street by Rodin, or who knows, maybe it was Camille Claudel. The copyright on that is most likely expired, because Rodin's been dead for quite some while, so has Camille Claudel. If somebody were to go and put a mask, maybe the person who can complain is the gallery owner in front of whom the statue is placed, or on whose property the statue is placed, maybe complain of trespass. But it wouldn't be a moral rights infringement because moral rights are probably expired. Moral rights have the same term as copyright. So copyright, the term is life of the author plus 50 years in Canada. In other jurisdictions, it varies. Sometimes it's life of the author plus 70 years. And then in a number of European countries, you have exemptions for the wars. So sometimes you can find, if you've had an author who's lived quite a long life, which is why I didn't want to pronounce myself because I don't know exactly on what year Rodin died, or Camille Claudel. So I didn't want to pronounce myself as to whether copyright was expired. But in Europe, sometimes if you have an author who's lived quite old, you could have some very long copyright with the war exceptions and the 70-year term. So if you and your buddies decide to go and put a mask on a statue, well, depends which statue you do it to.
Mm-hmm. So it depends which statue, the intentions, and also whether or not the copyright has expired. So, for instance,
if it's expired. I mean, the thing in the Eaton Center is that you had a defendant with deep pockets. You know what I mean? Mm-hmm. There's something to be gained. If a student sticks a mask on something, I'd be more afraid of getting a ticket for trespassing than getting a lawsuit for moral rights infringement. But you never know.
Yeah. Well, if I decided to take a famous artwork and maybe modify it a bit and make phone cases, let's say, and sell it, now I have a business commercial purpose or an intention, to profit off this idea, though I may not own the artwork that I'm modifying. So essentially, if the artwork is relatively recent or the artist is still alive, in that case, definitely I wouldn't be allowed to do so. But if it was in Canada, the artist had passed away, and then we're 50 years in the future, in that case, I would be allowed to use, to take those sculpture, put on a T-shirt, maybe.
Maybe yes, maybe no. Le Petit Prince de Saint-Exupéry fell into the public domain not very long ago, a few years. Mm-hmm. And what his estate is doing right now is it's obtaining trademark protection over the various characters in Le Petit Prince. So, the Petit Prince, and then the fox, then the rose, the guy who...
Which is why if I wanted to bring in Romeo or Juliet inside a novel I'm writing, or I wanted to bring in any other... if I wanted to bring any other fictional character inside a book I'm writing, I can't do so because I don't own these rights exactly how you're...
It depends. It depends on the book. I mean, if you want to bring in Mrs. Havisham, I mean, chances are there's no more copyright in her personnage. Now, I mean, if you want to bring in Snow White, I mean, as long as you're not reproducing the Disney Snow White, the Brothers Grimm have been dead for quite some time. So it really depends on what it is you're doing. You'll find that once you get into litigation, there's really no hard and fast rules. Oh, Grimm's no hard and fast rules. Everything turns on its own facts. And similarly, just because you don't have an intent to make money doesn't necessarily mean that you get off scot-free. It really depends on the context.
Mm-hmm. That makes me think of, kind of related to this, I think. Again, this is a very complex subject, intellectual property, but I can't help thinking of, for example, rappers. They have tattoos on their faces, and it's very much a part of their brand. Or I think of Michael Jackson's glove, or Dwayne Johnson, The Rock, a famous actor who has a shoulder tattoo, which is shown a lot in the movies he's in. Are these things a part of intellectual property, since it is technically the brand of that actor or performer? How would that work? It's something I've always thought about.
Well, here it's really complicated because tattoos are work of art, so yes, they are protected by copyright. But at the same time, if somebody reproduces a tattoo of somebody else on somebody else's skin, it's not like any court's ever going to order to rip out the tattoos. So tattoos are perhaps not the best example for that reason, but also because there what you're getting into is the right of personality, which is that's not really an intellectual property right. It's in Quebec, it's set out in the civil code. There's been a number of cases in Quebec of artists with varying degrees of fame who have complained about their image being hijacked for commercial purposes. Generally speaking, they win. I mean, what they win is not astronomical, because remember, we're in Quebec, so damages awards are never like humongous. So here, if you had a tattoo that was highly representative of somebody, well, the first question is, does that person even own the rights to the tattoo? Maybe the case of the rights are still with the tattoo artist or whoever designed what the tattoo artist was copying. So we don't know that. Then the second question would be, has the tattoo, by virtue of long use and association with that person, become representative of that person? And then they might be able to assert personality rights in the tattoo.
Okay, that's interesting. So Nick, kind of, I would love to hear you compliment kind of what Daniel was saying. If I were to take a white glove on my right hand and start performing and start singing on stage, would I be essentially infringing on Michael Jackson's artistic virtues, or pretty much, would I be infringing on the copyright that he may have on wearing a white glove on stage while singing?
And obviously, it's an excellent question, and it's an interesting question. I think that when you would approach this question, you turn towards the different categories of intellectual property rights, and you do, by process of elimination, which one would fit best within this particular situation. Obviously, we're not talking about patents or industrial design, so we can knock those off altogether. That leaves us with question with either trademarks or copyright. I mean, again, are we, then copyright, are we fitting in within a work of literature, a dramatic work, a musical work, or an artistic work? No, I don't think the fact of wearing a white glove, but then again, is one of those. With respect to, I don't know, so when it comes then we're left with a trademark, and then it depends on how creative a lawyer is and who's the judge that's on the other side, I mean, and when it comes to a trademark, it's some sort of, I don't even, that it's interesting because even the definition of trademark fits, there's certain categories of trademarks, within. Mm-hmm. So, it's an interesting question. And maybe, if you have a creative lawyer that goes before a judge and you have a famous enough artist, you could convince the judge to maybe, to maybe try to create some new law if you're in a common law jurisdiction, or maybe to influence it. It's a tough question. Unfortunately, there's no straightforward answer. I would have a field day with the case if ever it fell on my lap. Yeah. Daniel, would you have a little bit of fun arguing that there's?
Or to see how you're going to swim your way out of that one.
We put you guys a bit on the spot.
How long has that been around?
Well, it's funny because I have this image. I mean, obviously, the question is like if I just see a glove, so let's say here, if I'm out of the screen, I don't have a glove in my room, but just you have the hand with a white glove, a bedazzled white glove. Will a consumer immediately associate the performance to Michael Jackson?
That's merely a accessory to the performance.
Okay.
I think that the better example would be you have a costume from a famous circus. We won't name any circus because there are more than one circus. And they spend quite a bit on developing costumes. They obtain an industrial design registration on the costume. There, I think you've got a good bat to go after somebody. But the other thing is that, all these protections, you have to have brought something to the market. Mm-hmm. White glove, I mean, people have been wearing that for quite some time. I'm not sure there's anything very new there. And then if we're going to go the trademark route, because there is such a thing as trade dress protection. So, for example, if you go inside certain restaurants, without even knowing the name of the restaurant, you know that you're in that kind of restaurant because all these restaurants look the same. Similarly, there's some stores. So to give one example, Apple obtained trademark registration over the getup of its stores. The Michael Jackson glove could fall under that, but it's a pretty minor aspect of what he's doing. Then again, if somebody starts singing Michael Jackson's song, start doing the moonwalk, plus wearing the glove, you put all that together, there you've clearly got infringement of a variety of things. Might be copyright, might be personality rights. I've never heard throwing in trade dress for a human, but hey, why not? But just the glove itself,
it's not enough. It
keen on taking that to court.
Because also, I mean, if a judge were to rule in favor of that there is a right associated to the glove, it sets a dangerous precedent also, for cases.
I think you'll find that judges on the whole tend to, at least in IT, it's a conservative bunch. Often not because of any ideological bend, but because of the facts that are presented to them. One example of this is the name of the architect escapes me, but there's a Canadian architect who built a very modern-looking church out west, somewhere in the prairies. And the church eventually wanted to build an extension. And they didn't hire that architect, they hired somebody else. And the somebody else tried to do a pastiche of what that architect was doing. He sued and lost. And his point was, I want the integrity of my work. They can slap whatever they want next to it, but I don't want somebody, trying to do in the manner of what I did. And he lost. And the main reason he lost is that he had this all decided on an interlocutory injunction. So an interlocutory injunction is an order from the court to stop doing something until there's a trial on the merits. The problem here is that on an interlocutory injunction, the judge decides on a very, very summary file. He doesn't have complete evidence in front of him. He has some argument, but obviously not as detailed as he would have on a complete trial. And the judge had many reasons for not letting the architect win, but you just feel an undercurrent when you read the decision that this is an interlocutory ruling. So there wasn't a full thrashing out of the issues. So the judge, I think, felt very uncomfortable applying the dispositions of the Copyright Act, which dealt with moral rights. And this was the first time that they were ever applied in Canada.
So it would be hard for a judge. Oh, sorry?
I said, again, you always have to look at the context.
Yeah, no, you're right. We have to look at the context, and the summary that you both gave about the Michael Jackson glove, I think, paints the picture. It's not just a question of having an idea or doing one aspect, but there has to be many things that come together in order for you to have a compelling case, but also for you to start infringing on someone else's work.
No, not necessarily. No? The best protections are the narrowest protections, in the sense that, no, the best protections are the broadest protections. But sometimes, in order to have the broadest protection, you have to protect a specific feature. So, for example, if you try to shove too many things in an industrial design registration, your defendant will say, well, I only reproduce 1 out of 3 features, so I'm not really infringing. And that's a valid argument. If, on the other hand, you obtain an industrial design registration which is limited to one specific feature, you catch everybody who does that feature. So it's not always the case that it's the aggregate. Sometimes it's just doing one thing. It depends what that one thing is. There's really no cut and dry answers.
That's interesting. And and you just spoke about bringing in broad patents or broad copyrights rather, and narrow ones, and the idea of code is one that comes up to mind because we have these programmers that are writing incredible code, but can you actually copyright code? Could you protect code that you made? Because all it is text on screen, right? So
literary work, so yeah, it can be protected. Enforcing it's another story.
Mm-hmm.
So when you're dealing with program code, you can protect it. Well, it is protected by copyright just by virtue of its creation, provided it meets the criteria. But then on the other hand, you can also protect it by patent application.
Mm-hmm.
So a lot of software companies file patent applications for software simply because you can get a greater breadth, because you go and instead of being limited by the actual lines of code, you actually go and protect more or less the functionality or how the code operates, providing examples of code or pseudocode. Yet the patent application or the patent is going to cover how the program functions and what it ultimately does.
Okay. So if I were to make an app where I'm scrolling down a feed of pictures with some captions and some text and comments, I would be essentially infringing on Instagram's patent, even though I could.
If Instagram has, I'm not, again, if presumably, again, we give the example if Instagram has a patent on a specific way of maybe of displaying or scrolling through text. There may be a risk there, but again, the thing is that for a patent to be granted, the underlying technology has to be new, has to be inventive. So if you create something, if you create an application program and there's nothing new or inventive as those terms are defined in the law, the government's not going to grant you a patent for it. If you make if you submit an application for a patent, and if you don't have an enforceable patent, no one's going to be infringing that patent, right? You're not going to own one. So, but if you are developing an application program, yes, there is a risk that your software may infringe another party's patent. It is recommended to do proper due diligence to see if there are other patents out there that you may be ultimately that you may be impeding, that you may be infringing. So patents do exist in the software space.
Okay, that's interesting because we mostly think about patents for physical products, but definitely.
I don't know if that answered your question, but it
did.
Broad scope. An example I've given, I was giving a course the other day, and an example that I came up with was a patent to improve the coloring of the flesh of salmon, because when you farm salmon, salmon is not so naturally when salmon's in the environment, it feeds on crustaceans, it feeds on produce that have a pigment, and by virtue of eating that particular food, if you eat something with that orange pigment, that's what allows it to, or that's what provides it with that orange color of flesh. But if you're farming salmon, if it's not wild salmon, it's farmed salmon, then that salmon doesn't actually have that pigment because it's not eating crustaceans. So what companies do is they provide pigmentation to the salmon for them to eat. Anyway, all that to say that there's a patent out there for improving the color of salmon's flesh in order to give it that orange hue. There's also, patents on recipes of making candied tomatoes that have been granted by the Canadian government. There are patents on diagnostics. There are patents on technology for improving the taste of foods. Obviously, software. It's a very, very broad scope. There's a lot that you can protect by virtue of a patent.
Interesting. Now we have to wrap up the podcast in a bit, but we have two last questions. And one has to do with Canada. I'm going to move away from patent law a bit. I've noticed, driving by the streets here in Canada, the McDonald's logo here, the symbol has a little Canadian maple leaf on it, when compared to let's say in the United States, where there are no maple leaf logos, it's just the regular M you see around the world in all the McDonald's around the world. Is there a reason for that? Why is that not, why don't we see that in another country, for example?
Well, yeah, in other countries, there wouldn't be a relevancy to having Canadian maple leaf. So they put it on because they want to, let's face it, McDonald's is an American brand, so they want to somehow Canadianize it. What you have to know, though, about the Canadian maple, so the 11-point maple leaf, which is a specific representation of a maple leaf, it's not just any maple leaf. This specific maple leaf is a subject of an order in council that was adopted in 1965 when the Canadian flag was adopted. And essentially, the way the order in council reads is nobody can claim exclusive rights to the Canadian maple leaf, which is why whenever you see somebody who applies for a trademark and it has the Canadian maple leaf inside the 11-point maple leaf, there will be a disclaimer on the right to any exclusivity over the 11-point maple leaf. So the first criteria is nobody can claim exclusive rights over the Canadian maple leaf, which makes sense. It's the national symbol. It should be open to all. Second criteria is that it has to be used in good taste. So that's all we. But essentially, the purpose behind the order in council was to enable basically anybody to freely use the Canadian maple leaf and nobody to monopolize it.
Okay, I see. So, okay. So,
would there be a...
Sorry, go ahead, Marc.
No, go ahead. Go ahead, Kosta.
Well, the reason why I asked that question is that it's obviously, about brand strategy. They want to appeal to the Canadian market, and I get it. It symbolizes something for McDonald's. But I guess that leads me to one last question. I'm sorry, but I want to ask this. A lawyer in general, especially an IP lawyer, do they act as, say, a person who figures out all the legalities of, let's say, signing contracts related to IP law, whether it be patent or trademark or copyright and all of that stuff, and just figuring it out? Or can they act as some sort of consultant, as like, say, a business consultant for brand strategy? So you can bring on an IP lawyer and basically figure out how to market your company. Same with McDonald's. Maybe they brought in someone to figure out how they would go about their logo with the little Canadian maple leaf. Is that question clear?
It is.
No.
I think what Kosta was trying to say was I think basically it's as lawyers, especially in IP, are you solely there for the purpose of filing a patent, figuring out what copyright infringement some other company is doing on you, or do you have a more holistic purpose? Are you there to help the company take their hand and help them strategize?
Is the way the question's framed. Obviously, there's not a single lawyer who's ever going to tell you, no, I'm not there to help my clients. I mean, we're all there to help our clients. Now, the question is, what do you do? I mean, I'm an IP lawyer. I'm not Don Draper. We don't come up with jingles and we don't come up with slogans. What we do is we will be able to tell clients, well, if you use this one, here's a problem that you have. Or we'll be able to say right from the start, this one's worthless for whatever reason. Then what's interesting is to get the feedback from the marketing guys who say, yeah, but we really want this one. Then we tell them, yeah, but it's really worth nothing. So it's an interaction. And I'm a big believer that nothing is ever done in isolation. The best work is when you butt heads with somebody else. So no, we don't come up with jingles. Yes, we help our clients etch out a competitive space. And we also help our clients avoid getting into trouble. And on top of that, we do what you conveniently dismissed as all the legalities, which is pretty important. And here we have a very holistic purpose, right?
I believe so. And I would add also that also from a technology point of view, in a way, when you're looking at protecting technology that a client is coming up with, it forces the client to really evaluate what are the essential components of what they're creating and where they should invest their funds. So what I mean by that is when you're drafting a patent application, a little bit like what Daniel was saying, where you can sort of really focus on some specific essential components of a product. Similarly, in a patent, you don't go ahead and you necessarily protect the whole thing. You help the client imagine how this product is going to manifest itself in the market. So I think it was because Kosta's question was, as an IP lawyer, you do a lot more than just than answer looking at the legal side. Well, what I want to say is that looking at the legal side, the legal side actually pushes the client, the customer, to imagine or to how the product is going to be used, and actually pushes their business model. So there really is a discussion. It's a meeting of the minds between the attorney and between the R&D or the marketing people. So the example that I wanted to give is a printer. Okay, so say you've invented a printer. You bought you come to me with a printer, and we look at the technology and we say, okay, how is this invention going to be used by the average customer? And how can we leverage that use to ultimately make money for your company? So one of the questions that I ask is, okay, so that product, how is a competitor going to enter the market and benefit from your product if your product is successful? So the printer. So when you look at a printer, what is the element or the components that are most likely going to have to be changed or that are going to fail?
Change or fail?
The ink, the cartridges.
Yeah.
The you have to change the ink. You have to change the roller that feeds the printer. Maybe the scanner itself.
So exactly. You're right on point. So when you look at a printer, the ink cartridge is an element that is going to be changed. When you look at companies that develop printers, the amount of patents that focus purely on the ink cartridge, not on the printer, on the ink cartridge, because they want to make sure that if someone comes in the market and starts manufacturing, the ink cartridges that can be used with their printer, they want to make sure those parties are infringing or committing patent infringement. And they go so far in some cases as having microchips installed in their printers that are compatible with the printer, that ensures that no other cartridge can interact with their printer, because they would need a specific kind of chip. And the patent covers the interaction between the chips of the printer and of the cartridge. Mm-hmm. So as a patent agent, when a client comes and sees you with a new product, we say, okay, how is this product going to be used in the market? Do we want to patent the whole product? Or do we want to patent only that component that is most likely going to fail or that is going to be replaced on a regular basis?
Okay, because the usage of the the use of the printer doesn't, a printer's a printer, but the money-making machine are these cartridges, so that's why they want to pour as much money as they can into protecting it, so that you don't have a knockoff, or at least another company either copying or making other cartridges for this printer's brand, for the printer brand. Sorry.
Exactly, Mark. Because the fact of replacing the cartridge is a as big or even greater market than the fact of just selling the printer itself. That's really where you're going.
Okay, so I would guess Nespresso or Keurig all have proprietary patents on their cups.
If it's inventive, that's the thing, is that, and then, the patent agent may tell the company, the attorney may tell that company, find me an inventive way such that your cartridge can interact with your machine. And then we'll patent that interaction. In other words, make it in such that your Nespresso cartridge, and I haven't checked the patent portfolio of Nespresso, so I can't actually, provide any opinion on that. But, if they would have come to me with that problem, I would have said, okay, design a machine that interacts in a very specific way with the cartridge, and design your cartridge such that no other forms of cartridges can work with that machine, and we'll patent that inventive interaction.
Okay.
Because if not for that interaction, you cannot get that particular coffee cartridge in that machine, and therefore a competitor is not able to create secondary cartridges for your machine.
Essentially, it's about exclusivity and profiting out of that exclusivity, because you're the only one that can sell a specific product. That would be the big goal.
You come up with a great idea, you come up with a great product, and other companies, when they see that you're successful, they're going to try to find ways of piggybacking on your success. And you want to make sure that you prepare and you have intellectual property rights that are able to block off those ways that people are trying to get into your market. And every time you're dealing with a new type of product, you have to do that analysis. You have to put yourself in the shoes